Namaskar dosto. Today I am here to discuss the recent Patna High Court judgment that quashed the increase in reservations to 65%, which was based on a robust state-based caste survey conducted in Bihar. This Patna High Court judgment has raised many issues. Friends, as you all know, the Marathas, the Vaniyar, the Jat reservations earlier on were all set aside by the Supreme Court on the grounds of the non-availability of quantifiable data. So the sole reason for knocking off all these reservations was that there was no quantifiable data. Most of these reservations were based on small sample-based surveys and few bias commission containing their own partymen without any state-wide data collection, unlike the Bihar caste census. Mind it, Bihar caste census involved a data collection from almost 12 crore families. It is, in a sense, the X-ray of the Bihar state, and it probably reflects the real state of affairs of socio-economic, educational status of various caste groups within the Bihar state. Now, the question of empirical data is not an issue in this case. Like in Marathas, in Jats, in other cases it was an issue because it was all based on small sample surveys. But here it is not. Nor this is a case where a new caste is being included. For example, in the Maratha case, the Marathas were being included as a new BC category or a backward category. Nor it is a case of subcategorization. For example, in the Vaniyar case, they wanted to be included as the most backward category, and a new category was wanted to be carved out for the Vaniyar caste. That is also not there here. Nor this case is a case where the SC caste are further categorized. That is, for example, in Karnataka, Andhra, and then many other states, there is a movement for subcategorization within SC caste. So all these things are not involved in the Bihar caste census. The only question which boils down in Bihar is the increasing the reservation quota for the extremely backward class, that is EBC, from 18% to 25%, the backward class BCs from 12% to 18%, the scheduled caste from 16% to 20%, and the scheduled tribe from 1% to 22%. So the overall reservation has been raised from 50% to 65%, and this actually breaches the famous Indira Sahani judgment. So before actually going into this, let me now show you how hastily this caste census was done. The caste survey was notified on 6/6/2022, then completed by 5/8/2023. The report was first published on October 2nd, 2023. Then in the first round, they just published the population figures. They did not give the real socio-economic report. The socio-economic report was published on 7th November, and on 9th November, the bill was introduced. So, and if you see the socio-economic report, it is only talking about data. It does not give any rationale why there should be an increase or escalation to 65% is needed. Just publish some data, and then this caste census, the increase of reservations to 65% were carried out. So this gave enough ammunition to the High Court, especially the Patna High Court, to knock this case off. And I am going to discuss this, how they used the same data which was published in the caste census against them.